Good evening, everyone who is on the East Coast, and good afternoon to all those who will be joining our Zoom from the Pacific. Some folks have signed up. I'm Dmitri Glinski. I welcome you all to our association's roundtable on the crisis in humanitarian protection for those who have come to the United States, having fled from Ukraine, as well as Russia as a result of the Kremlin's full-scale invasion of Ukraine. As many of you know by now, our association is a grassroots organizing an advocacy network of de facto refugees and other migrants from several ex-Soviet countries. And it's led by migrants, it's led by former refugees. I'm one of those migrants myself. I came from Russia over 25 years ago, largely as a result of my disagreement with Putin's policies, specifically on the Chechnya war. We started this association, we launched it in 2012, organizing to support the wave of new asylum seekers from Russia who were fleeing to the US due to Vladimir Putin's return to the presidency and the crackdown on dissent. And back then, we started our engagement with Congress, including during the campaign for the first Magnitsky Act. And if some of you will be interested to look up on the Tom Lantos Human Rights Commission records of their hearing back in 2012, there is our written testimony in support of the Magnitsky Act shortly before it was passed. So that was before Crimea, and the words Russian-speaking were still largely non-controversial. Our association is American Russian-speaking Association for Civil and Human Rights. Moreover, Russian-speaking meant that we were not a Russian organization, but rather facing all those from ex-Soviet countries for whom Russian has been the shared language. Well, the times have changed, and we are in the process of rebranding, but this is a topic for another day, and we will be speaking English here today anyway. So this roundtable is both a continuation of more than a decade of our work, but also the first of a kind. It is a sequel to the series of events of our project, the anti-war action and dialogue of Ukrainians and Russians in the diaspora, that we launched back in 2014 at Columbia University, with some distinguished participants of the Soviet-era human rights movement in both countries, such as Andrew Grigorenko, to whom I particularly am indebted for the concept, for this idea of this roundtable and originally, and for being one of its co-founders. We did this in response to the invasion of Crimea, being the first non-Ukrainian diaspora organization to condemn it. And as the name of this project says, we also took action by holding joint Russian and Ukrainian protest rallies in front of Russia's missions in several US cities. Since then, both dialogue and action have continued and expanded mainly through our international roundtables online with participation of human rights leaders directly from Ukraine. In 2023, we were honored to present this project at the UN headquarters as International Day of Democracy. That said, today's event is not like anything we did before, because we are doing it from Washington in a hybrid form, and we are here largely because we have a message to members of US Congress, as well as to the media and to the general public. And this message will be about an acute crisis in humanitarian protection, in some ways a breakdown and a U-turn from this country's 250 years of welcoming those fleeing from war and persecution. And our message is a product of our exceptionally fruitful collaboration with brilliant Ukrainian community organizers and leaders, some of them also in the leadership of our association. And some are an independent group of parolees directly affected by this crisis. You will hear from them today, and I want to name them. First of all, Mariia Yatsko, sitting next to me, and the co-author of this event, so to speak. She has many titles, but the most relevant to us is that she is the vice chair of our association's chapter in Georgia. And while I'm doing this, I also want to recognize and introduce other members of our leadership present here. My co-host, another co-host on the screen, is actually the chair of our Georgia chapter, which is one of our largest and most active parts of the association, Julia Krotova. And I ask those whom I introduce if they can kind of wave their hands so that you can see them. Julia Krotova is a lawyer and a political exile from Russia. We have also here with us in the room Maria Bulachova, who is our coordinator in Washington, D.C., and I'm very pleased to have her here. We have next to her sitting Anna Nayfeld, who is one of our leaders in New York and a paralegal who helps Ukrainian and Russian refugees for many years and is also from Ukraine originally. And I think I saw Yulia Zhenzherova, also one of our board members and vice president of our Russian-speaking community council. She is originally from Ukraine, and she is one of our leaders in New Jersey. Going back to our group of directly affected Ukrainians, not all of them want to be named by name for security reasons, but among those who do, Yulia Wozniak, who is sitting on the left side of the table from Refugee Women's Network in Georgia, is here with us, and a group of others on Zoom, including Margot Lubchenko, who will also speak today after our main speakers. So we are truly honored to have our distinguished panel of main speakers whose work on behalf of the Ukrainian community shines in these dark times. And I want just to briefly introduce them. Maria and I will do this later in more detail. We have Anna Smit from the Ukrainian Immigration Network. We have Yael Chaker from the Refugees International, Hillary Lee from Justice Action Network, and Michael Corcoran, one of the two first Ukraine fellows in the US Congress, the assistant to Congressman Quigley, and a trailblazer in the sense of having basically been the one with the first freshly established position, hugely important for the Ukrainian community. So now I just would like to introduce Maria once again, who is a Ukrainian community leader and national advocate working at the intersection of immigration policy and refugee integration. I want to add that we also sit together in a national coalition of refugee migrant-led organizations called We Are All America, where no other Russians or Ukrainians take part. She is the author of a national petition advocating for a pathway to permanent residency for humanitarian parolees, which we have also promoted since last year, with a focus of advancing legislative solutions, such as the Ukrainian Adjustment Act. And her work centers on strategic advocacy, community engagement, and sustained emphasis on systemic immigration challenges.
Good evening, everyone. We are very happy and excited to have all people who joined us for this very important and difficult time to discuss the issues. The round table marks 4 years since the launch of the Uniting for Ukraine program. At the time, Uniting for Ukraine represented a fast and effective humanitarian response. It allowed hundreds of Ukrainians to find safety in the United States. However, today we are in a very different situation. The program has been suspended since early 2025, while the war in Ukraine continues. And for many of those who came under Uniting for Ukraine and other temporary pathways, return is not safe or realistic option. This is why today's discussion is so important. Our goal is not only to reflect on what has worked, but to move toward clear, actionable policy solutions. The United States created humanitarian pathways, including Uniting for Ukraine, temporary protected status, and access to asylum. These programs provided protection at a crucial moment. However, and now seeing both report and in practice is growing disconnect between how the system is designed and how it operates today. We are seeing a set of structural issues that are closely interconnected. Timing misalignments, processing times exceed the validity of the status itself. Work authorization gaps. Individuals lose the ability to work while waiting for decisions. Eligibility limitations. TPS cutoffs and asylum constraints leave many without protection. Process unpredictability, inconsistent adjudications and lack of transparency. Financial burden. The cost of maintaining status is becoming unsustainable. Legal gray zones. Limited access to long-term pathways. These are not isolated problems. They are different dimensions of the same systematic challenge. At the same time, enforcement trends raise additional concerns. We are seeing increased use of detention, individuals affected while their cases are pending, and growing inconsistency in how protections are applied in practice. This points to a gap between policy intent and real-world implementation. At its core, the system is built on temporary protections. Parole is temporary, TPS is temporary, asylum is limited. But the conditions that required these protections have not ended. Temporary protection was designed as a short-term response, but the reality it responds to is no longer short-term. That's why today's discussion brings together multiple perspectives: litigation, legal practice, policy analysis, and life experience. With what I would like to turn to our speakers who will help deepen this discussion and move us toward practical, informed solution. And first of all, I would love to start with Anna Smit from Ukraine Immigration Task Force. Anna Smit is a Ukrainian-American attorney based in Washington, D.C., where she advises individuals and organizations on immigration pathways, humanitarian protections, and regulatory procedures. She is the Executive Director and Regulatory Counsel for the Ukraine Immigration Task Force, a non-profit legal coalition of almost 250 attorneys that assist Ukrainians seeking refuge in the United States. Founded in 2022 to help Ukrainians fleeing the war, the task force publishes guidance on immigration law, provides educational webinars to the public, and consults nonprofit that assists Ukrainians with immigration and resettlement. Prior to her work in the immigration sphere, Anne held positions in government and private practice. Her expertise includes regulatory compliance, corporate governance, contracts and licensing, commercial transactions, employment law, and consumer financial regulations.
Thank you very much, Maria, for inviting me to speak at this important event. So first, I want to mention that much of what Maria mentioned earlier today is what we try to help Ukrainians with every single day. And, what I'm going to go over mirrors everything that she summarized, but in maybe just a little bit more detail. So the immigration laws themselves have not really changed. There was one act signed into law in 2025. And of course, there was a bill signed into law in July 2025, which primarily affected immigration fees for parolees for applications. But other than that, it's really the regulatory effect of the many executive orders and the directives that have been given to the Department of Homeland Security, the Department of Justice, and the Department of State that have affected Ukrainian immigration. With respect to parole, about 240,000 Ukrainians were paroled through the Uniting for Ukraine program between May 2022 and December 2024. And this is before DHS indefinitely suspended the program in January 2025. Approximately 30,000 additional were granted humanitarian parole at the southern border between about January, February 2022 and April that year. And at the same time, a lot of Ukrainians tried to enter. Unfortunately, that Uniting for Ukraine program was suspended in January 2025, and this means no new sponsor applications were accepted, and even those Ukrainian beneficiaries who had already been vetted and approved were not issued travel authorizations to come to the United States. So this unfortunately has not shifted, and we're not sure if the administration is going to do anything to bring back the program in full scale. But the good news is humanitarian parolees are allowed to apply for reparole, and typically we are seeing reparole approvals for 2 years. So that's the good part. There have been a few glitches with obtaining re-parole, and there was about a 4-month suspension in application processing, which Hillary will discuss shortly. But we're finally seeing a steady stream of re-parole approvals. So those who filed in the last 6 months or so generally processed fairly expeditious and within 2 to 3 months. So the new approval period for parole, re-parole is generally granted from the expiration date of the previous parole period, which sometimes means that parole has already expired, and so the re-parole period will begin the day after. And that's the same situation with employment authorization renewal. The bad news is some parolees are experiencing very long delays with re-parole and also with employment authorizations. We do have cases that were filed in 2025 and even 2024 that never still have yet to be adjudicated, and unfortunately, there has not been a successful way to expedite them except through congressional intervention. Some people have had to file a second application, which means paying again, and in that case, we're seeing them approved more quickly. We're also seeing individuals be requested to submit additional evidence for re-parole, and they just need to show why they're unable to return to Ukraine, which is generally pretty straightforward. As long as they can submit that, USCIS will typically resume their application and issue a decision. So that's sort of the summary of what's happening on a day-to-day basis. But there have been some malfunctions in the past few months. Some were related to application fee payment. Others were related to incorrect periods of re-parole. We also had some inconsistencies with employment authorization documents being issued that didn't match the validity period of re-parole. And then there have been a few cases where individuals paid the final parole grant fee, but were not actually granted re-parole. But with regard to the majority of cases filed recently, at least they are moving along. And with regard to work permits that are filed in conjunction with re-parole, we're seeing those approved also fairly quickly, sometimes as quickly as 2 weeks after re-parole approval. However, we're still seeing some delays with other EAD requests. For example, those that are not filed with re-parole, or just for whatever reason, they're delayed administratively, or just other issues that people are experiencing. And so, as Maria mentioned, this is causing some parolees to fall out of status entirely or to lose employment authorization. It makes them unable to work. So the other big change is the employment authorization documents, which had initially been valid for 2 years, or the duration of parole, are now only valid for 1 year. So parolees have to keep applying each year for a new EAD, which of course costs a lot of money and represents additional delays in having to wait. And especially for those who cannot file online because, for example, they might need to file a fee waiver for whatever other reason. And so their re-parole and EAD might take a little bit longer. And one of the biggest issues that parolees have experienced is the skyrocketing fees for filing, for re-parole, for EADs, and for a number of other applications. So in the past year, we've seen, I would say, maybe a 100% increase in those fees. So now it costs about $580 to file online for re-parole. $630 would be the mailing fee. And then the final parole grant fee is $1,020. And each of these fees is per person. And in addition to that, it costs $470 when filing for an employment authorization document, or $520 filing by mail. So if you're doing the math, you can see that a typical reparole and EAD renewal is going to cost between $2,350 to $2,450, and that's per person. So it is cost prohibitive for a lot of families, especially with multiple individuals who need reparole and EADs. And some of them are having to make difficult choices. So, unfortunately, that means either not applying for reparole or EADs, or maybe depending on TPS instead of reparole for status or for work permits. But the issue with TPS is it expires October 19th, 2026. So we only have 6 months of protection. And on top of that, there have been significant delays with TPS. We have applications that have been pending since late 2024, 2025, and that's both for initial applications for TPS and those who already had TPS and applied to re-register in 2025. So they're waiting a really long time. That means they're losing their employment authorization, and some of them are going to be out of status when that expires. And as of today, Ukraine's TPS has not been redesignated or extended. And I think, as Maria also mentioned earlier, not everybody qualifies for TPS. Only Ukrainians who entered the United States on or after August, I want to say 16th, 2023, are eligible to apply for TPS. So everybody who came before that, after that, is out of luck. So those are some of the issues with the short-term protections. And unfortunately, there are issues with acquiring long-term statuses as well for parolees. So in late 2025, this visas for Ukrainians. So unfortunately, this is not an option to pursue a green card at the moment. And even those who had won green cards in previous years are not able to adjust their status through that visa. And the other routes, which are either longer term temporary visas, such as work visas, or permanent residence, those are limited. So in the case of short-term visas, unfortunately, parolees are not eligible to apply for short-term visas from inside the United States. They would have to leave the United States, interview at a U.S. consulate abroad, and then they're really rolling the dice. They may or may not be allowed to come back to the United States. They might have advanced parole, which means that they were authorized to travel without losing their parole. But if they don't, they have to rely on a visa to come back in. And there's a similar issue with applying for we call them immigrant visas, which are for permanent residence. So in the case of family-based immigrant visas, parolees do qualify for those. And some of them have successfully applied to adjust their status through a family-based immigrant visa if they have a relative in the United States who qualifies as a sponsor and everybody, is approved for their petitions. But in the case of employment visas, unfortunately, parole is not considered a lawful admission or a lawful immigrant status for purposes of applying for an employment-based immigrant visa. So from within the United States, they cannot do this. They would have to leave the United States and apply through consular processes. And even if an employer were to sponsor them and file a successful petition, parolees are not allowed to adjust their status inside the United States because of that legal restriction of parole. So these are really challenging legal frameworks for parolees, and asylum, being one of the last major routes to permanent residence, is not particularly viable for most Ukrainians because Ukrainians would have to not only prove that they have faced or will likely face significant persecution, but also that their government inflicted the persecution or could not protect them from another entity that inflicted that persecution. And so in the case of Ukrainians, that's a difficult legal hurdle. So we do have Ukrainians who are applying for asylum, but it is a very slim chance. So unfortunately, to summarize everything Mariia said, there are not really a lot of remaining short-term protections for Ukrainians. And the long-term options are limited to either consular processing, which means leaving the United States, or, holding their breath for diversity visas, or, marrying a U.S. citizen, which of course is not an option for everybody. So, and I don't want to talk longer than my allowed period, but immigration enforcement as well. So typically we see a lot of commercial drivers, rideshare vehicles, people in traffic stops, minor, minor traffic violations. Those people have been arrested more frequently, but we're also seeing situations in which Ukrainians are detained at USCIS interviews, in other types of immigration raids, or occasionally in other situations where they might encounter law enforcement for something different. So this is definitely a very serious issue, and we're working together with other organizations and with members of Congress to try to come up with tenable solutions for both the short term and the long term. So with that, I'll turn it over to the next speaker.
Thank you, Anne, very much for laying out this picture very thoroughly and clearly, which is usually challenging. And as I would summarize what I heard is both the system looking as if it wants to extract as much money in fees from the people while keeping them in uncertainty and fear. Before we move to our next speaker, I will expand our conversation a little bit, because we as an organization really see this as a holistic issue affecting people fleeing from this war, both from Ukraine and from Russia, because several hundred thousands of Russians left their country in first big wave right after the invasion, second big wave when Putin announced his partial mobilization into the army. Many had to return back because they couldn't find a place for themselves in another country, but it is also part of our concern. And I want to say that in conjunction with this meeting, we have published a report that we have been preparing in the past few weeks with participation of many of those at this table. And it is on our website. I just quickly share one page from it. I will not obviously read you the entire report, but I just want to give you a few highlights that we have used the externally reached data that was recently extracted from DHS by the Deportation Data Project based at Berkeley. I want to give a shout out to them. We're not having direct contact with them. They have been able to obtain granular data all the way to March of this year, current year. We analyzed it along with some other sources and pulled out by bits and pieces the data on the detention and deportation of Russians and Ukrainians since January 2025. And we are sharing with you this quite alarming picture that calls for real congressional oversight of ICE detentions, where we have Russian and Ukrainian children, not just adolescents, but toddlers, some spending 10 months and even over a year in detention. We have both Ukrainians and Russians with their asylum cases in the process of being adjudicated, either by immigration court or by BIA, and they have been deported by the court decision, clear violation of due process, at least from my non-lawyer opinion. And that is 17% of all those Russians and Ukrainians deported. Besides these kinds of numbers, which I think are similar in some ways to those we see in other immigrant communities, we also raise broader systemic issues of a special challenges faced by our people. That Ukrainian and Russian de facto refugees are in a special position because neither have a natural institutional home within American society, neither church-based like Catholic Church, nor based on race and ethnicity. As a result, Ukrainians and Russians are in many ways excluded. And I would sharpen it by saying even at times discriminated in immigration services, in funding for their initiatives, in hiring in large NGOs, and in recognition by the media. I have observed it for 15 years of our organizational work in our base in Northern Manhattan, where Russians known to be connected to the Russian government have better access to our local and federal government officials and have even worked in high-level government offices, while our anti-war political exiles and refugees in our mixed Ukrainian and Russian community cannot get a break for any grant or government job and are being slandered behind their back by Russian government proxies. So we've been addressing this through full spectrum advocacy on local community board all the way to the United Nations, where we also have meetings these days. And we also address this in the recommendations at the end of this report, which I will briefly mention in my closing remarks. Now I would like to pass the floor to our next distinguished speaker. And I am very proud to introduce Dr. Yael Schecher, who is a director for the Americas and Europe at Refugees International, an independent organization in Washington, D.C., that advocates for the rights and needs of forcibly displaced people. Yael focuses specifically on access to humanitarian pathways to the United States, including asylum, refugee resettlement, and parole. And before joining Refugees International in 2019, Yael taught about the history of immigration at the University of Connecticut, among other places, and volunteered with the Connecticut Institute for Refugees and Immigrants.
Thanks for having me. I'll say just a minute about what Refugees International is, just to zoom out for a second. My organization, I focus on the United States and the Americas mostly, and a little bit on Europe, but my organization focuses on global displacement all over the world. And we actually have quite a big project in Ukraine itself on internal displacement, working with Ukrainian civil society organizations and the organization Helping to Leave, which some of you may know, which helps Ukrainians kind of escape the occupied territories. We are also doing things like abroad, and I also do quite a bit of advocacy in Europe on the Temporary Protection Directive, which gives Ukrainians legal status in Europe. I should say I'm an immigration historian by training, as was mentioned, and when I lived in Connecticut, it was quite a large Ukrainian and Russian community, there were a lot of actually Russian and Ukrainian clients at the Connecticut Institute. I lived in West Hartford, which has a very big, a lot of people actually came from Crimea, I think around the time the Russians invaded. I've been involved with the humanitarian parole pathways since they were created during the Biden administration. And I think what I'm most frustrated by is the fact that the Biden administration, before it left office, did not do more to pass a regulation on the way out that would have protected parolees a little bit better. Wouldn't have been the be all and end all to protect people, and probably would have been challenged or tried to revoke, but it would have been harder for the Trump administration to do as quickly as they did, sort of rolling back what the Biden administration done, had the Biden administration done that. But especially it might have offered them, Ukrainians and other humanitarian parolees, a little bit more protection against the enforcement and removal that we're seeing, and that's mentioned in your really good report. So my organization is concerned with the problem of people losing protection and being potentially removed and sent back to harm. Like that is, we are a refugee focused organization. And so, I when Anne was talking about, the loss of EADs and the gaps that some Ukrainians, I know a Ukrainian family who didn't have a lot of means, and so couldn't really afford the fees and the reapplication. And when the breadwinner, the father of the family, lost his work permit, which was a factory job, basically, the family actually decided to go to Poland, where they thought they would have an easier time because at least they would have legal status if they moved there. And they knew some people who moved there. So they actually just moved to Europe. This was sort of towards the beginning of the Trump administration. And I helped hook them up with some Polish organizations that was working with Ukrainians, because it was actually a better path for them given their situation. And I've done the same thing for Haitians who are in a similar situation to Ukrainians. I've helped them get to Canada if they can. So this is not that uncommon because of the situation that some people find themselves in. Another thing that I think is a little bit unclear in our environment, and I'd love to just sort of like open it up if there's time for a conversation about this later, is like, what are sponsors or the supporters supposed to do right now for the people that they supported? Are they supposed to pay the fees? What are they supposed to do? Are they supposed to pressure Congress to do something? Like, the job of the supporters who sponsored so many of the people to come in through United for UK, and many of them were family members and relatives, but a lot of them weren't. And what are they supposed to do? What should they do? What should we be advocating for them to do? We don't want them to get in trouble and to be targeted themselves for enforcement, especially for harboring people who don't have status. So it is a bit of a line, but I think that could be a little bit more refined, and we can figure out what all those people who were so supportive of bringing people in are supposed to do now that those protections are being stripped away. I have been quite focused on the removals of but basically the detention and removals of both Russians and Ukrainians. I wanted to just say, in February of 2025, before the Trump administration and continuing into the Trump administration, I visited detention facilities, and there are a lot of Russians who end up in detention. A lot of Russian asylum seekers end up in detention. This has been going on for a long time. So I just wanted to emphasize that. And when in February of 2025, right when the Trump administration came into office, there were still Russians trying to cross the border, seek asylum. Many of them had fled. They were political dissidents. They had fled the war, and some of them were sent to Costa Rica with their families, and they ended up being separated from family members here. And then they ended up in Dili, which is a family detention center if they came back. So this is a huge problem. I mean, it's not going away. It's continuing. The removals to third countries is also really strange. It's something that I've been tracking. Most deportations of both Russians and Ukrainians are not direct, because the United States does not deport directly to Ukraine or to Russia, but it does it through third country proxy. So Poland is basically saying, we'll help you deport Ukrainians, which is a problem, and people should be pressuring Poland not to do that. For example, same thing with Egypt, which seems to be a pipeline for Russian deportations. And so this is very problematic. And one of the things my organization does is really try to pressure other countries not to work with the United States on this, because it's sometimes easier to pressure other countries than ours right now, which is kind of crazy, but that's where we are. In terms of recommendations, I wanted to say a couple of things. Like I said, I'm a historian. What's fascinating about what's happened in American immigration history is that, it used to be that there were a lot more, or it was implied that if you came as a refugee or in a humanitarian status, you were eventually going to be able to regularize. There was going to be an Adjustment Act passed by Congress in the 1990s, a slew, even though Congress passed a very, very harsh immigration law, the IRA in 1996, which is like basically the immigration law that we live with today, the enforcement law. There were also several adjustment acts that passed in the 1990s for various populations, including NACRA, which it sounds like it's for Central Americans, but was actually also for a lot of Eastern Europeans, Russians, and people who come from the former Soviet Union. So basically, there were these pathways created by Congress in the 1990s. And then after 9/11, like, Congress stopped doing this, basically, like stopped passing adjustment laws. And that is a problem. First of all, it creates enormous backlogs in the immigration courts and the asylum office. And one of the ways in the 1990s, what was then called the Immigration Service was able to clear the backlog was because Congress actually provided took people out of the backlog and gave them a path to permanency. So if a law can help clear the backlog, I mean, that's the whole point. That was one of the main reasons that they passed this, so that people wouldn't have to do individual asylum adjudications, which are, as was mentioned, definitely not a sure thing. The asylum grant rate for everybody right now is like 5%. So like nobody's winning asylum anymore, like nobody. Okay, not just Ukraine, like nobody, very few people. It was 30% during the Biden administration. It's like 5% now. So asylum is just not, the Trump administration is not granting asylum to basically, and to very, 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 very few people of any nationality. So it's just important to understand that. And so given that, especially, you have a bazillion cases in the asylum office, you have a bazillion cases in the immigration court, all of which are going nowhere or going to be rejected. And so, and the fact of the matter is that the other thing that's been dramatic since the 1980s, really, besides the refusal to continue to pass adjustment acts, is just like this proliferation of temporary status and these limbo statuses where people have to pay fees to basically perpetually stay in like an insecure status, as was mentioned before. It's a very good way of putting it. So I wanted to say one last thing. I mean, I think the biggest question I have for members of Congress and, and for us is like, what do Ukrainians actually want? Do they still see themselves as people who want to eventually go back to Ukraine? Or do we really, or does that not really matter in pushing for permanent status? And the reason I say this is like in the 1990s, the similar situation was for people who came from former Yugoslavia. There was really no concern that people were given refugee status, permanent status. If people wanted to go back after the war, fine. Okay, that's fine. So you go back. You go back. It's no big deal. The fact that, people were given refugee status and permanent status did not necessarily preclude the idea that they would eventually go back. And somehow we've now, like either in the congressional imagination or the president, the imagination of the executive branch, it seems like we can't hold those things together. This idea that we would give people a potential path to permanency without saying like, because we're doing that, that means none of everybody will ever go back to Ukraine and that they're mutually exclusive, basically. What I'm saying is that they're not necessarily, and I think it's very important for us to keep that in mind. There are a lot of people who went back to after the war in Yugoslavia, they went back. But they were granted, they could stay permanently if they wanted to. They had that option. It was like either you had the option to stay permanently or you could go back if you wanted to. And I think that's what's missing today. This idea that we should be giving people that option. And I do think we need to really think about what would an adjustment act look like? And I personally think that given the way that the Biden administration created, many, many parole programs for many populations, we should do something like NACRA, which was not just for one population. Okay, it was for Central Americans. It was also for several, as I mentioned, Eastern European populations. It was for Nicaraguans. It was for Salvadorans, Guatemalans, plus people from Poland. There were several people who were able to adjust through that law, and there were different processes for different nationalities, and that was sort of weird, but it was a good idea. It lumped populations together. It saw them as all having a similar problem, which was that they needed a pathway to stay because they came. So I think we should do that. And then I just wanted to say one really last thing, which is that, there's always been a tension between Congress and the executive branch over humanitarian pathways. Like, who has the authority to create these? And Congress, at times has said, it really should be visas, it really should be refugee resettlement, which is more, and the executive branch using parole, it seems like sometimes portrayed or was perceived historically, and this goes way back, into the 1950s, portrayed historically as like overreach by the executive branch doing what only Congress should do, which is only Congress should create these pathways. And I do have to say, that was really not that big of a problem until President Obama started using his discretion to create pathways. That's when basically Republicans started to have a backlash against parole that wasn't actually akin to the way it was before. There have always been like sort of a bipartisan view by some members of Congress that the executive branch should use parole in a very limited way, just because it was a basically, separation of powers kind of argument. The Republicans, since the Obama administration, have really taken a different tack toward this. I'm sorry to say, it's much more nativist driven. It's much more anti-immigrant driven more generally. It's coming from that impulse. It's not coming from a separation of powers impulse. And they're bringing in all kinds of arguments about fraud and vetting that are really bogus, to be honest with you, to sort of supplement the argument. So I just want to say that because there's a lot of arguments about how the parole programs are not secure enough, there's not enough vetting, there's too much fraud in the sponsorship. I don't think the evidence is there to prove it, really, but a lot of noise has been made about it. And I think it all stems from this period when President Obama was using his executive authority to do things that Congress didn't want to do after the failure of comprehensive immigration reform and, dock on other things that seemed like executive overreach. And that's really like the source of opposition to parole, not some sort of like pure separation of powers argument. I just wanted to say that. And I think I'm over time, so I will stop talking now.
Thank you so much, Yael. It's crazy to hear all that. Like, I had never imagined that Ukrainians will face what they're facing right now. It's crazy, and thank you so much again.
Sure.
So our next speaker today would be Hillary Lee, an attorney with Justice Action Center, where she litigates immigrant justice impact cases affecting policies and communities across the country. She is counsel on Svetlana Doye Vinoyem, a nationwide class action challenging government actions harming beneficiaries of various humanitarian parole processes, including Uniting for Ukraine. Prior to GSC, she served as policy counsel with Detention Watch Network and litigated immigrant justice and voting rights impact cases with Asian American Advancing Justice Atlanta.
Thank you so much, Maria. Thanks to my other speakers for really setting the scene. My goal today is to share about Svetlana Doye Vinoyem, our class action lawsuit, and give a state of play on where the case is and how it affects Uniting for Ukraine specifically. The scope of this case is much broader than U4U, but I will try to focus my remarks on U4U specifically. And so, as Maria mentioned, this is a nationwide class action. It was filed in the District of Massachusetts, a federal court there with Judge Indira Talwani. Our plaintiffs, who are the folks who brought the lawsuit, are parole beneficiaries and sponsors of various parole processes and an organization called Haitian Bridge Alliance. Justice Action Center, my organization, co-counsels with Human Rights First on this case, and we brought it like over a year ago now, and so a lot has happened. But the scope of the case addresses the government's actions as to a bunch of parole processes, like I said, and they include U4U, as well as the parole processes for Cubans, Haitians, Nicaraguans, and Venezuelans, CHNV, Operation Allies Welcome for people from Afghanistan, military parole in place, family reunification parole, and Central American minors parole. And so I'd like to list them all at the beginning just so we know the scope, but again, I'm going to focus on U4U. And just to make sure folks know, this lawsuit does not address individuals who came through CBP-1 appointments, which I know was the case for a lot of folks from different countries. And so some of the government actions that we're challenging are the termination of individual grants of parole. So far, the Trump administration has only tried to do so for people with CHNV and family reunification parole. Over the last year and a half or whatever it's been, they've tried to prematurely cut short grants of parole for these people so that they can then detain and deport them. So to be clear, I think everyone knows they have not done this for U4U grants, which is good news. But it's certainly possible that the government will continue to try to do the same thing for programs like U4U, like Operation Allies Welcome, and any of the others. And so our team is prepared to litigate those terminations if the government does move forward with something like that. And we have had success in challenging those terminations in other situations. The other piece of the case, or the scope of the case, is that we're challenging a couple suspensions of adjudications of immigration benefits applications submitted specifically by parole beneficiaries. I think Anne mentioned one, but there was one implemented at the start of last year where they suspended adjudications across the board of immigration benefits applications submitted specifically by parolees, based on these narratives that Yael was talking about of fraud and needing more vetting and things like that. And so that was in place until we were able to get it blocked in May, I think, of last year. And so that court order has ordered the government to continue to process those immigration benefits applications. And so that is still in place. The government did not go forward with an appeal of that. And so right now, that order is in place. The government should be processing those kinds of applications, and that includes reparole, employment authorization documents, green cards, TPS, all of those things. And I will talk a little bit later about whether that's actually happening or what our class members are seeing as kind of like ripple effects of those delays. But the court order is still in place, and the government should, in theory, be processing those and adjudicating them to completion. And so that's the main court order that's in place right now that affects U4U. Oh, I forgot the other challenge that we're bringing to a suspension of adjudication of immigration benefits is to a USCIS memo that was put out in December of last year that had various components, but specific to our case, we're challenging the pause on processing immigration benefits applications, again, for our class members. And so that memo is actually, or our challenge to that memo is actually not specifically related to U4U, because we're only challenging the part that affects people from countries that were identified as high risk by the government, which doesn't include Ukraine. But I mention it because that memo also has an across-the-board asylum ban, which I think is being litigated in other cases. But most recently, the government put a notice in our case that they are kind of selectively lifting that asylum ban for countries that are not on the high-risk list. And so my understanding is that asylum applications for Ukrainians should also be moving forward, although, with the caveat that Anne was mentioning that, and that Yael was mentioning that those grant rates are extremely low and the cases are extremely hard. Was there an issue with the...
No.
Okay. Okay, great. So yeah, that's where we're at. I just want to make sure everyone's clear on the court order that's in place. Since it's a class action, our nationwide class includes all U4U beneficiaries. And so any U4U beneficiary with a pending application for reparole or a work permit or another immigration benefit is part of our class. And that court order should extend to protect them, unless they've left the US and remain outside, or if they opt out of the lawsuit for some reason to bring their own lawsuit. And so that is the current state of play. We have a few other motions that are still being litigated. Most are not directly relevant to U4U. So the one I'll mention is that we've filed a motion for discovery, which is just a process in litigation to try to get a bunch of information and documents from the other side. And so we're asking the court to order the government to provide us with documents and communications related to how they're complying with this court order that I've been talking about. We want to know more about this, this vetting and this screening that they say that they're working on. And we want to know what they've done to actually make sure they're resuming processing to the state that it was before this suspension was put in place. So the court has been holding on to that motion for quite a while, but we continue to nudge her about it whenever we can, and hopefully we'll get something from her. So then the next piece that I want to talk about is based on the fact that this is a class action and we have this court order in place, we are in touch with tens of thousands, maybe more class members across the country who have signed up for our email lists. And I will share the information for that because we would love any and all beneficiaries who are class members to join our email list and be in contact with us if needed. And so through those communications, we've been learning of a lot of the similar issues that Anne and Yael were talking about. But I'm going to highlight a few that we've been able to address with the Department of Justice and with the court. And so we've been hearing that many U4U class members have been having issues specifically with their reparole applications, as well as other benefits applications. And these include holds that have not been lifted from applications. The government was supposed to lift all these holds. Nothing is supposed to be suspended based on these previous suspensions. But oftentimes people still get messages from USCIS staff that say that their application is on hold for whatever reason. And often at times it's based on outdated information. It's based on USCIS staff who are not up to date, or like some of the explanations we've gotten from DOJ are like, this USCIS staff member was out of office and wasn't up to date on the training and stuff like that. And it's having a really concrete, direct impact on folks' applications. They're being held for months at a time or longer. And then it seems also, at least what DOJ tells us, that their systems have tons and tons of technical errors. Every application that we bring to them, they say, oh, there's an issue with the system and our IT is working on it. So these are the explanations we get. Obviously, it's with this extreme pattern of non-compliance here. We know there's more going on. That's part of the reason we're trying to get the discovery that we asked for. It's part of the reason we're always bringing these cases to DOJ. And we will not accept these explanations that are just an attempt to get past the court's order. And so we know that some of these holds are related to the previous suspension. Another piece that I think is also related to the previous suspension, as well as the government's goal of not providing status to people, is these major delays. It's great to hear that folks are getting reparole, especially people who have applied recently. Unfortunately, we've talked to so many class members who are seeing major delays in their reparole applications, some up to and over a year. I think I just saw someone whose reparole application has been pending for 21 months, which is almost the 2-year period that they would have gotten parole. And so we're doing our best to try to talk with class members who have this issue, and when the parole delay is when the reparole delay is very lengthy, we have been able to bring those cases to DOJ's attention. But again, seems like a pattern that can't be accidental, I suppose. And then the other issue, to elaborate a little bit on some of the reparole payment issues, is we're talking to a lot of class members, I think hundreds of class members, who were not being granted reparole even after they paid the $1,000 fee, which is supposed to be like the last step and kind of an automatic final step before you get reparole. So they just weren't getting it. Or there were issues, I guess technical issues, with their payment not being linked to their reparole application. And so they would pay, and then the website would say that they hadn't paid, even though they had paid. And so we were also able to bring those to DOJ and successfully got a lot of those issues fixed, which we're really glad to be able to have done. And then, of course, there are other issues that folks are facing. These are really just the major ones that we've been in conversation with class members about, given the scope of our case. We hope to continue to be able to go to the Department of Justice and the court to raise issues, including holds, extreme delays, and issues with the payment, and then whatever else might pop up for folks that we can. The scope of our case is certainly limited, but our goal as a co-counsel team is to kind of be able to bring the broadest scope of issues possible to DOJ. There are certainly things that are out of our hands that we might not be able to bring because it's just not related enough to our litigation. But we have a really diligent and amazing team monitoring our class member inbox all the time. And we're always discussing these issues, and we're trying to do our best to advocate for our community members and our clients. And so on that note, I don't know the best way exactly to share this, but I'll put it in the Zoom chat for now. This is our class action lawsuit website. And so if you are a beneficiary or you know and love beneficiaries of these parole processes, including U4U, we encourage folks to sign up directly here for email updates. And there's also a contact us form, and that's where you can email us if there are issues with your case that we might be able to help with, or if you have questions about the lawsuit. And so please share that widely with folks who might benefit from it. And this is also the place where I have to note, I am an attorney, but our organization is a legal organization, but we cannot assist with individual immigration cases or applications, cannot represent you on your case. For that, we recommend seeking a trusted attorney. But if you do have these kind of big picture issues like holds on your application or other barriers to accessing the relief and the protections that you're seeking, please do reach out through that website.
Okay, thank you, Hillary, for this. It's great to have the very knowledgeable and confident, but also very compassionate legal firepower on the side of our refugees. Yeah, and the only thing that got me really disappointed is the last thing that you said, that you don't take individual cases, because we have such a deluge of folks sitting in detention, their families approaching us. If 2-3 years ago, we had people, we had lawyers in our network that were taking people for free consultations, and now can't get even paid help because there is such a big volume. So I'm just putting this out there so that folks know that we do seek and appreciate assistance with individual cases as well. I wanted to introduce one more member of our leadership who has joined us, and that's Alexander Borochkin, who leads our chapter in Portland, Oregon, and who is a scientist and also a political exile from Russia as a result of this war. Here he is. Now we are moving to our next speaker, whom actually Julia will show his bio on screen in a second, and whom I met in person this morning, listening to his enlightening presentation about how to talk to Congress, Michael Corcoran. And when I heard that, I just thought that there should be a Michael Corcoran school of congressional meetings, which I'll most likely fail, which is part of the reason why I decided at some point not to live in New York rather than Washington after my several years in DC working with some congressional offices around the turn of the century. But Michael has been playing a great role as a national security professional, more than a decade of experience shaping U.S. foreign policy and international development. He has served across multiple federal agencies, the U.S. Agency for International Development, that has played such a huge role in our history, the Department of Defense and the Department of State, advancing foreign policy and assistance initiatives throughout Eastern Europe and Africa. Most recently, he was Ukraine Deputy Team Lead at USAID, advising senior officials on U.S.-Ukraine cooperation and assistance during Russia's full-scale invasion. And now he is in Representative Quigley's office, where he applies his policy expertise to support congressional engagement on Ukraine and national security while gaining deeper insight into the legislative process.
All right. Good evening, everyone. Hello. My name is Michael Corcoran, a Ukraine policy fellow with the Office of Congressman Mike Quigley. Congressman Mike Quigley represents the north side of Chicago, Illinois' 5th District. He's a Democrat, and he really wanted me to be here today to hear your voices and hear your experiences, to take messages back to him. So thank you for sharing all this important information with me, and thank you to the event organizers for organizing this event and inviting me here to speak. Since Russia's full-scale invasion of Ukraine in February 2022, the United States has played a critical role in providing humanitarian protection for individuals fleeing war. Through programs such as Uniting for Ukraine, which extend temporary protected status, the U.S. has offered safety to hundreds of thousands of Ukrainians who were forced to leave their home due to Russia's unprovoked aggression. These programs have allowed beneficiaries to work to support their families and contribute meaningfully to communities across the country while maintaining lawful presence during an ongoing and active conflict. However, over the past year, our office in Chicago has increasingly heard from constituents participating in the U4U who are facing significant challenges related to processing delays, reparole, educations, and employment authorization renewals, many of we just heard about earlier. These delays are resulting in lapses in documentation, interrupted in work authorization, and prolonged periods of uncertainty for families in Chicago who have complied with all program requirements. In many cases, individuals who timely filed for renewal or extension of status are waiting months for education, with some experiencing gaps in employment authorization through no fault of their own. This creates serious economic and personal consequences in Chicago, including housing instability, loss of access to health coverage, and other essential services. Our office has also heard concerns regarding the financial burden associated with maintaining status under current fee structures. For many families who fled Ukraine with limited resources, these costs are substantial and in some cases unsustainable. As Representative Quigley has stated, humanitarian parole programs are most effective when they're administered in timely, predictable, and transparent manner. Delays and administrative backlogs undermine the intent of these programs and the stability they are meant to provide. With respect to Ukrainians, it is important to underscore that the underlying conditions driving displacement remain active. Russia's ongoing attacks on civilian infrastructure in Ukraine continue to pose significant risks to return, and many beneficiaries of these programs do not currently have a safe or viable option to go back. At the same time, we recognize from other conflict-affected regions, including Russian nationals who have expressed opposition to the war or faced political persecution, also raise serious protection concerns that must be educated through fair and consistent process under U.S. law. The scale and severity of displacement caused by Russia's full-scale invasion against Ukraine remains the central humanitarian driver of these programs, and it's essential that U.S. policy continue to reflect that reality. Congressman Quigley has consistently supported efforts to ensure that Ukrainians in the United States are able to maintain lawful status, avoid lapses in work authorization, and access timely education of pending applications. He has also urged the Trump administration to address backlogs and restore predictability to the processing of humanitarian parole and related benefits. More broadly, the United States should continue to uphold a humanitarian protection system that is efficient, consistent, and capable of responding to large-scale displacement crises in a way that reflects both our legal framework and our longstanding humanitarian commitments. So I'm really here to listen to all of the messages that you have all to say and to take note of them and to take them back to Congressman Quigley and to think about more ways that we can leverage his position as co-chair of the Congressional Ukraine Caucus to elevate this issue on Capitol Hill. And it's very, if I can say personally, discouraging and frustrating to hear all these stories of what's going on. And it's awful. So I appreciate all the insights you have to share about what's going on, and I'd like to take that back to Congressman Quigley. Thank you.
Our next but not the last speaker would be Yulia Wozniak from Refugee Women's Network.
Thank you so much. Good evening, everyone. My name is Yulia Wozniak, and I work as a community outreach worker in Refugee Women's Network. So maybe in my role, I work directly with, like Maria said, I work directly with Ukrainian families who came to the United States through the United for Ukraine program. And I would like to share some numbers based on my work and our internal data. So among my clients, 73% are waiting for a parole renewal for 3 to 18 months. About 90% are waiting for TPS renewal, including work authorization, for over 12 months. Only about 5% have received TPS renewal approval. In addition, around 40% of people who applied for a parole received conditional approval. They pay the required fees, but still have to wait several more months to receive final approval. We have also noticed an important pattern. Within the same family,
different members receive different outcomes. For example, women and children may receive approvals faster, while men are left waiting much longer. In some families, a mother and one child receive approval, while the father and another child are still waiting. In other cases, parents received approval, but the children do not. And sometimes children receive documents faster while the parents remain in uncertainty. This creates additional stress and inequality within families. Cases submitted more recently, especially after October 2025, are starting to move faster. However, many people who applied early are still waiting. Their cases are not moving. They're not receiving answers. They are simply told, wait. That's it. However, we have seen that one of the most effective ways to address these delays is by reaching out to congressional offices here in Georgia. Their teams of congressmen have been incredibly supportive and responsive. In many cases, after such a request, we see faster decisions. We are truly grateful for the support and for the help they provide to Ukrainian families during this difficult time. At the same time, unfortunately, this is not the reality in all states. We have heard from Ukrainians in other states that their congressional offices are not always responsive or willing to support their cases. We truly hope that this situation will improve and we can try today together to create a nationwide solution to this issue. So when people cannot receive their documents on time, it affects every part of their lives. It creates stress, anxiety, and stability for families who have already suffered because of war. From my experience, this is not just about documents, cases, or numbers. This is about people's lives. There is a real people. So thank you so much for attention.
So our next speaker is Margot Lubchenko, who is also an directly affected person, as well as a community organizer and volunteer for grassroots community of Ukrainians. She is in Illinois, I believe in Chicago. The floor is to Margot Lubchenko. I also want to thank her as well as other participants here who contributed to our report that is on our website. Please.
Thank you very much. Hello, everyone. I came to the US in 2023 under the Uniting for Ukraine program. And originally I'm from Kharkiv. This is second city of Ukraine, located just in 30 miles from the border with Russia, which is being attacked day or night. I am a business analyst here. I'm running small consulting agency. Also, I'm a law student, and also I'm a volunteer with a grassroots community of fellow Ukrainians who came to the US under the U4U. Currently, our headcount is nearly 7,000 people. So we are facing very similar problems every day as a result of the immigration policy pivot that hit in 2025. You already heard the statistics, numbers, and the main problems, but I'm here to deliver 5 personal stories of people I know. Some of them are on the call as well, so that you can get a personal touch on who are behind those numbers. The first story is the story of Olha. Olha, please wave to the camera. She's with us today, Olha Smolova. Okay. Lonpin. So she's from Poltava, and she came to the US in March 2022. She has a successful hotel management career. She continued it here, and she also has been saving for surgery on a childhood hip disability. It was planned for the last year, for 2025. But her parole and work authorization expired on the verge of the administrative hold in March of 2025. She lost her job, her lease, her health insurance. The surgery never happened. After cumulatively of 18 months of calls, interviews, expedite requests through the USCIS account, senators, congressmen, which all were met with your cases within normal time frame, her reparole finally came through just a couple of weeks ago. But her work authorization will arrive already expired due to processing times and policy changes, forcing her back to the square one. But this time without savings, with mental and physical health already deteriorated. Second story is the story of Elena. She's a single mother from Odessa and raising a 10-year-old in Minnesota. She worked two jobs specifically to avoid relying on public benefits. She worked as a school lunch lady and warehouse worker with glowing recommendation and everything. Her work permit expired in July 2025. In order to comply with the law, she stopped working, and consecutively, she and her daughter had to move to another place of life because they were not able to afford their current apartment even after subletting the room. Her expedited requests were rejected despite the full documentation was uploaded into the case. Her total waiting time currently is 15 months, and currently, she's been 9 months without any income. Third story is the story of Victoria, who is also a single mother, but she's in New York State. Her son is a college freshman. Their parole expired in January 2026. Her expedite request was approved 12 days before expiration and never acted on. 4 months later, the case still not moved. She wrote to 2 senators, to 1 congressman, and all returned the same answer from the USCIS: wait. Not eligible for TPS because they arrived to the US after the cutoff date of August 2023. Currently, they are both in legal limbo and risking the deportation process through no fault of their own. The story number 4 is the story of Yuri, who is currently on the call. Yuri is a naturalized citizen in Colorado. He's sponsoring 5 family members, his parents and his sister with 2 children. His father waited for TPS approval for 2 years. His sister's family is still waiting for TPS for more than a year, and if approved, it will run only through October 2026, as it was already mentioned on the call, since there is no extension or redesignation period on a horizon. Unfortunately, they cannot go back. Last summer, a drone struck a building with a family's apartment in Kyiv. The windows blown out, the shrapnel inside apartment, other damage. And despite all of this and all of these evidences, their e-request got a 60 days waiting response, and their senator never replied. Last but not least, Yulia. Yulia is also on the call. Currently, she is based in Chicago, and Yulia is one of the lucky ones. Her reparole came through in time, but her work authorization was mailed to a wrong address despite an updated account. This is a recurring problem since December 2025. Basically, after your parole gets approved, you're gambling like, which address should I check, if you ever changed it. So she paid and refiled for a new document, but processing times for new work authorization running up to 5 months, leaning toward the 5 months, and her employer is already asking for a valid document. She may lose job waiting for a card that system has already approved. I can continue for a while. These issues are spotted all over Ukrainian diaspora in each state, from East Coast to West Coast, North to South. All these people obey the law, pay taxes, pay filing fees. But the conditions that forced them to live in the first place are still there, if not more drastic, and no region in Ukraine can be considered safe, to be honest. Nevertheless, the system leaves us only two choices. First one, fear of instability, depleted savings, mental, physical health damage, and possible deportation from the US, or fear for our lives in Ukraine. Relocation to other country except for Ukraine or the US is a very hard task because there are very limited options where people could go should they have financial or mental health resources. So I want to summarize that we are not asking for handouts. In the short run, we are just asking for a response in a reasonable time on cases that were timely filed and paid for. Should you have any questions, please do not hesitate to reach out.
Okay, thank you, Margot. We're already beyond the time that we allotted for this, however, very important conversation. I see Julia Bigbova, who is a distinguished Ukrainian-American lawyer in Chicago and also in the Ukrainian Immigration Task Force and contributed to the rise of our association, for which we are truly grateful. I would like to give the last few words to the people directly affected, to those who have been through this crisis personally with their families, with their closed ones, both Ukrainians and maybe some of our Russian participants who are here would like to say something. And if they prefer to say, for example, in Russian, I will quickly interpret briefly, and in Ukrainian, Maria would interpret. So don't hesitate if you feel your English is not, but please be very is not good enough for you to speak in English. But please be very brief. Please limit yourselves to a couple of minutes, 2 or 3 minutes, not more than that.
I can start.
Anyone? Yes.
Yeah, so with Margot's help, we were able to prepare some questions in advance. So I'm going to start with the first question that we have. If anyone actually sees any effective legal or administrative tools available to address the systematic delays affecting our cases.
I'm only commenting on the parole payment issues. We recognize, USCIS has recognized that there are denials and also lack of final parole grants because of the pay.gov payment issues not being reflected on their accounts. One thing that's worked for us with our clients is to upload evidence of the pay.gov payment and call USCIS directly and speak with them. And we've had a lot of success with them applying the payment and even reversing some of the denials for non-payment. I just wanted to mention that.
We have one more question, if that works.
Yes.
So it's from the list from the questions that Margot actually has prepared for us. And is there any legal basis for filing a collective, like so-called class action lawsuit in relation to the prolonged processing time, and would such action be advised in our situation, actually?
We talked about it. Well, I can't tell you yes or no on that because it really takes a deeper legal analysis. If you're interested in that, you would want to talk to an attorney or an organization that handles unreasonable delay cases. Certainly cases like that have been brought, and there are claims that can be made, but I can't get into detail with that. And I will say unreasonable delay as a claim is challenging, and that's part of the reason we didn't bring one in our case, for example.
We have one more question in the room. Yeah, go ahead.
Hi, I would like to direct my question to you, Michael. With all the TPS people, and we know TPS expires in October. As far as I know, during this action summit, they're not advocating to pass any legislation on this issue. Are we seeing that most likely nothing will be passed on TPS and TPS will expire? Or is there a chance, should we be advocating more? What is like realistic approach? We all know that we should always be talking about this, but we have 6 months and so many people leaving on TPS and expecting something. Should they be getting ready to that?
Yeah, I think that's a good question. I don't know, honestly, whether it will expire or not. With the event organizers of the Interaction Summit, a lot of us were geared towards the message of advocating for sanctions against Russia for the Senate. But I think it's a big point that citizens should be raising this with the members of Congress. And I do think it kind of fell to the wayside, you know, the event organizers, the Interaction Summit to raise this. I think it's a good ask, and I wish the organizers did a better job addressing it.
Because we are running out of the time, and I do understand that Ukrainians have a lot of questions, not a lot of answers. As Dmitri in the beginning shared with our website, you are willing to email any questions you have. We will connect you with all specialists we had today during the round table. We suppose our today's event will move some actions, and Ukrainians will receive an answer and will receive their documents. Slava Ukraini!
Thank you, Maria, and thank you to our amazing speakers. I'm so grateful that you all agreed and you participated not just in tonight's event, but in preparing it substantively, intellectually, and that we will have some solutions. As one thing that I would like to propose as a suggestion here for everyone is those who are here today, I think we need some kind of a task force to work on these issues for the future, both on Ukrainians and on Russian anti-war refugees, and to devise some, with Michael's help as well, advocacy solutions, and with government and with media. With that, thank you all again. We'll send you the link to the video once it's ready, and I hope to engage with you in the future on this and other topics. Have a good night, everyone.